Let me refer at this time to the text of some of the proceedings that transpired in court, and perhaps this may change the argument because you say it's fraud.
Yes.
But he argues, Mr. Anguilari now, which is part of the proceedings that played out in the court,
Yes.
he denied resigning his position within the contemplation of the provisions of Section 306, sub 1, 2, and 5 of the 1999 Constitution. And he says the purported letter he sent to the Speaker was not meant to be acted upon by the House of Assembly.
Wow. A deputy governor writing such a letter.
He goes on to explain.
And he said it was not intended to be implemented.
He goes on to explain. He says, quote, I did not submit any letter of resignation to the fifth defendant, in this case is the governor.
Okay.
And then he says, or any other person other than the Speaker. I only submitted a purported letter of resignation to the Speaker.
A purported.
But I never intended to comply with the strict provisions of Section 306, sub 1, 2, and 5
just
of the 1999 Constitution submitted to the governor.
That is an admission against interest. Very interestingly.
This is out of context. Yes. Let me read the latter part. Maybe it will explain a little further. Okay. He then goes to say that the intentions... he submitted the letter to the Speaker with the intention of discussing the content with him privately at a more convenient time to alert him at a possible action I may take at a later date because of certain political developments in Adamawa State. Hence, he did not submit it to the fifth defendant here he referred to as the governor of Adamawa State, as strictly stipulated by Section 306, sub 1, 2, and 5 of the 1999 Constitution. He then, therefore, was shocked to see that his letter was read and acted upon by the entire members of the House of Assembly when it was addressed to them.
Exactly. These legal issues arises from that passage you have just read out. One, if that is true, then it's an admission against interest. Two, there was no way there. He said, I never. He said, purported letter of resignation. Purported. Then the third aspect of it is this. When you say purported, until the court rules on it, it's not, you are claiming it's purported. But the question is this, what was your intention as at the time you wrote it? You said you didn't want it to be acted upon as a deputy governor. You write a letter. Then it comes to question your personal integrity as a deputy governor, as well as the Speaker himself. Then, you see, again, let us look at that depositions critically. What is the role of a lawyer under our rules of professional ethics? Is it to mislead? The role of a lawyer under our professional ethics.
So you think it was misleading here?
Of course, from what you have just read, look at it. Professional conduct. One of the fundamental requirements of the professional conduct rule is that you must be the forefront of the promotion and projection of the rule of law. You must not even help your client to circumvent the law.
All right.
So when a person in a position of a deputy governor and a lawyer of his level now say, I wrote a letter, a purported letter, I didn't want it to be acted upon. Are you promoting the rule of law or to circumvent Section 306?
Don't forget.
Yet, today you are getting the benefit.
Don't forget, he's also a politician.
He's also a politician. I will just quickly, I will conclude this because I'm very bitter about what has happened.
Before you conclude, I think we should just hang on a minute because we need to get the views of another legal practitioner, Malaki Ugomando. He joins us via phone today to give his perspective on this matter. Morning, and thank you for joining us. What do you think of this conversation so far?
Well, good morning.
Or the judgment, I should say.
Chamberlain and my good friends, Sulaiman and Amaka. Good morning, Mr. Fred. Let us know, Fred.
Go ahead, please.
I have watched with keen interest the debate over there. I appreciate the tenacity of your views, but I'm humbly not particularly persuaded by the fact that your argument, especially largely also, is anchored on the fact that the governor was nowhere to be found as at the time Ngilari submitted his letter. Now, if somebody comes to my chambers, because that is part of what must be examined, particularly regarding the entire circumstances of what played out in that scenario. If somebody comes to my office or your own chamber and submits a letter duly addressed to you or myself, and that letter was acknowledged by my secretary or yours, if personal service is not expressly required, and when I say personal service, and that is that you must be the one to acknowledge, will that suffice as service to you? The question being that what is an issue is not that the governor must have received it himself. If he addressed the letter to the governor, and the letter is received in the governor's office, that would have been sufficient. But what I seem to understand from what you're saying is that the governor was not even anywhere to be found. So the bottom line is the desperation of what is it called? Futility to be coronated as the governor. And what were the hurdles before him? He impeached the governor, and he went to obtain. Those are the facts that played out. He went to obtain that letter from the deputy governor. Being a lawyer and realizing that that resignation cannot be effectual except it's addressed to the governor, he handed him over what he wanted. And at that point, I think that those who have summoned the courage to push the frontiers of the law has assisted in deepening the democratization process. Good morning.
Thank you very much.
All right, thank you, Malaki. But from the depositions that we read out,
yes,
because you alluded that he intended, and deliberately so, to mislead the entire proceeding or process. But he says otherwise, that he did not deliberately write that letter with the intention of strictly complying with that, because he was
complying.
Yeah, because
is that what a lawyer should do?
No, but he says it was a letter he wrote
Is that
to be discussed.
Is that part of our duties as lawyers?
No, but what about the context?
The rule of law, or
the context.
Rule of law.
No, but the context with which he said it. Right. He said this is something I intended to discuss with the speaker.
Let me tell
as an action. No, he said as an action I may take at a later date. But he was surprised that it was read on the floor, saying that it was a letter of which was written to the speaker.
Even from what you have just read, the man never denied that, look, I have written that letter. But I said that, what he's saying is that, look, I had discussions with the speaker that this is the things we want to do.
Okay.
The question again, under the elementary evidence law, can you use oral evidence now to debunk what you have written expressly, documentarily, what you have written down? Can you use oral evidence? Because as I said,
this was not oral. Wasn't it also part of the proceedings in court?
If it was
part of the argument,
it must be written that, look, this was what we discussed, and what we discussed was an extension of my letter to you. Because once matters have been reduced into writing, under the evidence that you can't give an oral evidence or oral testimony to contradict what is expressly stated there. Unless you want to allege that there was a fraud, that's grant. You can allege that, oh, yes, I wrote that, but I was misled. If fraud was played on me, that is why I wrote that letter.
What if it says it was under duress, for instance?
I don't think that's what I was even thinking that happened, that maybe God was put at the man said.
Yes.
But the man did not even say that.
No, but
he said I deliberately wrote that letter.
Assuming that was the case.
If that was the case, a gun was put at him.
Yes.
Anything done under duress in law has no force to stand. It still amount to fraud. So it's like you going to the police station and say, oh, write a statement that you stole so. Issue a check for us. We have a similar case now where police collect a check on behalf of somebody in the police station. I say, if you don't write this check and sign it, you will remain there. And the man say, okay, I will write.
Okay.
To get my freedom. So, but the point I'm trying to make is this, and which the Supreme Court has made abundantly clear, is you can't benefit from your wrong. The two of them, they have had their hands on it. And like you said, it's a matter of politics being introduced. Unless we lawyers begin to insist on sanitizing the system, the politician will continue to pollute even the constitution we have. And let me quickly just read this to you. It's very short. And that is the judgment of the Supreme Court in Teriba, Pasademo, very recent, 2010, on the duty of a person not to benefit from his own deliberately created wrong. Quote, a person cannot benefit from his own wrong. In its adjudicatory functions, the court has a duty to prevent injustice in any given circumstance and avoid rendering a decision which enable a party to escape from his obligation under a contract by his own wrongful act, otherwise be made to profit by his own wrongful act. Unquote. That's my case.
All right, that's where we'll also rest the segment. Thank you for coming on, Mr. Fred Agbaje, legal practitioner. We'll be back in just a moment. Join us again.